Hello learners, today I'm going to give a brief about intellectual property law. There's something known as creative property, which is created by creative human minds, intellect and intelligence. And that needs protection too. And that is why we have the intellectual property law. So what are the intellectual property rights? IPR as we call them, refer to the legal rights given to the inventor or creator to protect his invention or creation for a certain period of time. The importance of IPR is increasing due to the rapid pace of technology, which disseminates new and valuable ideas every day. The economy of the countries depends on industries resulting from these ideas and startups. The more the advancement, the more is protection needed against piracy, counterfeiting, and other infringements. So if we go to define it, intellectual property rights is any and all rights associated with tangible assets owned by a person or company and protected against use without consent. So we're supposed to either take permission or acknowledge that which is due to them, because intangible assets refer to non-physical property, including right of ownership and intellectual property. Some of the examples are patents, domain names, industrial designs, service marks, logos, trademarks, design rights, and all other things that are listed down here have protection. We deal mainly with trademarks, copyrights, patents, and trade secrets here. So there are three types of property, if we see: real, personal, and intellectual. So real is the real estate or land, personal is items of possession or identifiable things, and intellectual is the products or ideas of human creativity and brain. So the aim of IPR is to protect the knowledge created by human effort. Secondly, to stimulate and promote further creativity. It's supposed to motivate and inspire others also to create new things. There has to be a balance between these two. The owner's rights to remuneration and public need for competitive market. We need many people so that there is a competition and a competitive edge for quality. As Shepard Fairey has rightly said, the most important thing about intellectual property versus creative expression is that copyright law was created not to stifle creativity but to encourage creativity. So we begin with trademark. The first one, a word, name, symbol or device is called a trademark. It indicates quality and ownership of a product, and it distinguishes it from other people's products. There's a service mark also, which is the same name, logo or brand, but it is applied to a service instead of a product. Trademark can consist of slogans, designs, sounds, guarantee and quality. You can see the examples listed there. All Big Macs taste the same. This is McDonald's hamburger, talking about its quality and guarantee. Then they are not protected if they are generic or merely descriptive. They'll be protected if they are coined, arbitrary and suggestive. And the examples are given there. Trademarks are governed by federal law, the US Trademark Act, and it's also called the Lanham Act. Registration is not required. US Patent and Trademark Office, that is the USPTO, which we normally call it, and it is protected from the date of the first public use, has validity of 10 years and is renewable. Copyrights refers to writings, literary, dramatic, music, artistic, advertising, work and cartoons, etc. What is not protected in this is the titles, names, short phrases, lists of ingredients, ideas, methods or processes. So copyrights are handled by the US Copyright Office. In India too we have the Copyright Office. The registration is not required by USPTO and it is protected when work is in fixed form. The validity for given is during the lifetime of the author and 70 years after his death. Patents. Now, patents are a grant from the federal government, that's the USPTO, permitting an owner of an invention to prevent others from making, using, importing, or selling it. We have three types of patents: utility, design, and plant. So, utility is automobile, and design is furniture, plant is hybrid flowers, and they are handled by the US Patent and Trademark Office. For this, registration is required by USPTO. It protects useful, novel, and non-obvious ideas. Uh, Insignificant addition or alteration also. The validity is for 20 years for utility and plant and 14 years for design. Then there are trade secrets. Any kind of valuable business information that if known by a competitor would afford the competitor some benefit or advantage is known as a trade secret. But there's no limit to types of information. It can be recipes, financial projections, anything. So registration is not possible. There's no federal law protection given, but it is, however, protected by the state statutes and the codes of law. There is a non-disclosure agreement. There's not to compete agreements, and the criterion is secret gives owner a competitive advantage and is valid forever. So those are trade secrets. There are three major international agencies: International Trademark Association, World Intellectual Property Organization, World Trade Organization. Then there are international agreements: the Berne Convention, the Madrid Protocol, Paris Convention, North American Free Trade Agreement, and TRIPS. I'll be dealing with these in my later videos. So, intellectual property rights are often intersecting and overlapping each other, but they are nonetheless important, and a knowledge about these is essential today. Thank you.